Good morning, friends, particularly my esteemed colleagues in legal profession, friends and fellow citizens. Today, I am before you to speak on an issue that goes to the very core of our constitutional democracy, the issue of selective justice, bail jurisprudence, and the crisis of constitutional morality. My dear friends, the issue of selective justice and disturbing erosion of bail jurisprudence in contemporary of India is creating flutters. Bail, liberty, and the Constitution. The Supreme Court of India, many a time and again, reiterated a fundamental principle of criminal jurisprudence. Bail is the rule, jail is the exception. This principle is not a judicial charity. It flows directly from the Article 21 of the Constitution, which guarantees personal liberty, and from the universally accepted principle that every accused person is presumed to be innocent until proven guilty. Similarly, for a convicted person who is serving a sentence, the principle is exactly the opposite. Jail is the rule. Parole and remission are exceptions, granted sparingly for exceptional reasons. These principles are not technicalities. They are the moral backbone of civilized legal system. But today, I am before you to say, with a sense of deep concern, that these principles are being systematically reversed in practice, not accidentally, but selectively. Constitutional and legal foundations. Our Constitution rests on three non-negotiable pillars. Article 14, equality before law and equal protection of laws. Article 21, life and personal liberty and judicial independence. As a part of the basic structure of the Constitution, Baba Sahib Dr. B.R. Ambedkar, the father of Indian Constitution, was very categorical that the constitutional morality must guide the institutions, not the ideology of the party in power, not religious majoritarianism, and not political convenience. The judiciary was envisioned as a sentinel on the qui vive, the last refuge of citizen against the might of the state. Bail jurisprudence developed precisely to prevent the state from punishing a person merely on the basis of accusation. Pre-trial detention was never meant to become a substitute for conviction. The reality today, reversal of the principles. Friends, let us now come to the ground reality. Today in India, under trials are punished without conviction. Convicts are rewarded with parole and remission. And liberty depends not on the law, but on the ideology and proximity to the power. The most glaring and recent example is that of Umar Khalid, a student activist. For more than 5 years, he has been incarcerated without a trial under UAPA, Unlawful Assembly Prevention Act, Unlawful Activities Prevention Act. So no conviction, no proven guilty, only allegations. On 5th January, the Supreme Court denied him bail and in highly unusual direction, asking him to apply again after 1 year only. On the very same day, a convicted rapist and murderer, Dera Baba Gurmeet Ram Rahim Singh, was granted parole for the 15th time. I wonder and not able to understand, as an advocate, what principle of law explains this contrast, what constitutional morality justifies this disparity, and what message does this send to the ordinary citizens? This is not a justice. This is a selective application of law, a pattern of selective justice. These are not isolated incidents, my friends. Look at the Bhim Koregaon case. Scholars, activists, lawyers, poets, and many of them, elderly and suffering from serious ailments, have been jailed for years under UAPA without a trial. Father Stan Swami, an 84-year-old Jesuit priest and a tribal rights activist, died in custody. He was denied even straw to drink water. This is not merely a legal failure, it is a moral collapse. Consider the Delhi riots cases of 2020. Victims of violence and peaceful protesters were booked as conspirators, while those who delivered openly incendiary and communal speeches walked free. Journalists, fact checkers, and writers are arrested under sedition, UAPA or IT laws for doing their professional duty, while hate speech by ruling party leaders often goes unpunished. Opposition leaders face swift arrest by the central agencies, but the moment they align with the ruling establishment, cases become dormant. This is not a coincidence, my friends. This is a weaponization of criminal law. Judiciary and the crisis of credibility. Let me be very clear. This is not an attack on the judiciary as an institution. The judiciary remains central to our democracy, but institutions derive legitimacy not from the power, but from the public confidence. When the bail is routinely denied to dissenters and activists, but generously granted to the powerful and politically connected, people begin to ask uncomfortable questions. Justice must not only be done, it must be seen to be done. Delays in bail hearings, prolonged incarceration without trial, and excessive deference to the executive weaken the judiciary from within. A judiciary that appears to lean towards communal or ideological affiliations ceases to be the neutral arbiter envisioned by the Constitution of India. Baba Sahib Ambedkar and constitutional morality. Baba Sahib Ambedkar warned us, however good the Constitution may be, it is sure to be turn out to be bad if those who are called to work it happen to be a bad lot. He also reminded us that the constitutional morality is not natural, it has to be cultivated. The judiciary's highest duty is not to the government of the day, but to the constitution and the weakest citizen. Courts exist not to validate power, but to restrain it. If dissent becomes crime, if bail becomes a privilege, and if liberty depends on the political loyalty, then the constitutional democracy becomes an illusion. Call to the legal fraternity and civil society. My friends, this is a moment for the legal fraternity to speak. Silence today will be interpreted as a consent tomorrow. Bar associations, senior advocates, retired judges, academics, and public-spirited citizens must defend bail jurisprudence, challenge misuse of draconian laws, demand equal application of law, and protect judicial independence from executive and ideological pressure. History will not forgive those who remained neutral when liberty was at stake. A final appeal, my friends. In conclusion, I say with utmost seriousness, if equality before law becomes selective, if liberty becomes conditional, and if justice becomes partisan, then the democracy becomes hollow. India cannot afford a judiciary that is feared by the weak and favorable to the powerful. It is a time to restore constitutional morality, to reclaim judicial independence, and to ensure that law is applied without fear or favor. Let us remember, the Constitution is only as strong as the courage of those who defend it. Thank you. Jai Bhim, Jai Bharat, Jai Constitution.